Can I?
Driver, not
Is it on? Okay.
I don't want to stand right in front of it there.
Nope.
Yeah.
Here we have Emily Kile, who was so amazing to donate her time to come out here tonight to give us some information on guardianship, you know, what to do when our kids turn 18 or actually start right before they turn 18, to how kind of better to protect and secure their future. So I will just step away and let you go.
Okay, fantastic. Well, thank you all so much for coming out on this freezing cold evening after that beautiful spring weather we finally got to have. I know that some people didn't get all the information in the packets and they're making extra copies. And if you still don't get the information, I left my business cards on the back table, and just shoot me an email and I'm happy to email you the information. I promise not to add you on any list, and I won't call you and all of that other stuff, but just so you can have the information that maybe you didn't get tonight. So I'm a bit of an overachiever, I have to admit. So each one of the topics, other than maybe ABLE, is probably an hour-and-a-half presentation unto itself. So I'm gonna kind of hopefully move along, but the slides have lots of information for you on each of the topics. My goal was to touch on guardianships, on special needs trusts, on SSI benefits, and on ABLE accounts, which to me are kind of the 4 top topics for people to think about when you have a loved one who has special needs. I am an attorney. We have an office in Scottsdale. I've been practicing since 1993, so 20 some odd years. We also have a full-time social worker at our office whose job is in part to help families find resources out in the community. We don't do case management, we don't do any of that, but it's really just there to be a resource to help people through and find information that they might otherwise not be able to find. I definitely encourage you to write your questions down, because as I move to the next topic, you might forget what it was that you thought was important about the prior topic. So, and then just I'll do my best to answer all of the questions that I possibly can. So, I think this is my clicker. So, as I told you, these are the things that we're gonna talk about tonight. So we're gonna go through each one of those. So first is guardianship. So guardianship is a court action. So you do have to go to court in order to become the guardian for somebody. And in part, it takes away some of the civil rights that the person has. We have one set of statutes for adult guardianship. So when a child is 17 and a half, we can file for guardianship for that person, and it will go into effect on their 18th birthday. But that is the same set of statutes that we have for somebody who is 90 and has Alzheimer's, or somebody who has a traumatic brain injury, or somebody who's not verbal and in a coma. So we don't have separate statutes that say, I have a child who's 18 and has a developmental disability, so I get special status. And I know it's really hard sometimes for parents when we have to go through all of this process where you feel like, well, they're just my kid, and they're still just my kid, they just happen to be 18 now. But we just have one set of rules for everybody. So it is a court action. And we think of guardianship basically as just continuing your parental role. So you keep pretty much all of the same status that you had as a parent in making health and housing decisions for somebody who's under guardianship. And the person has to meet the definition, which is sometimes difficult for the, I'll call them the kids, to hear in court, because the judge will out loud say, you've been deemed to be an incapacitated person in need of a guardian. And sometimes that's like not the greatest thing for somebody's self-esteem, and it's a little bit uncomfortable. And so that's why I warn you that that is a finding that the court has to say out loud on the record, because it's part of the statute to say that the person meets the requirements to need a guardian. One of the biggest questions that people typically ask me when I meet with them is, well, how do I know if my kid needs a guardian? And I don't have any idea. I've probably never met your kid. Maybe your kid is with you at the meeting, but I don't have any idea what their actual functioning is and their ability to make decisions. And it is a really hard choice, because quite honestly, I'm not sure that any 18-year-old kid is actually able to make their own health and housing decisions going forward, right? They're still trying to figure it out. Their brains are still developing. They still might not make the best decisions about things. So you want to think about how is this kid compared to a typical kid? How are they in their development? How are they going to be in terms of making those kinds of decisions on their own without help? And if you're the guardian, then you get to get medical records, you get to talk to the doctors, you get to talk to the school system. Whether your kid is obstinate or really cooperative, once you're the guardian, you have all of those rights to do whatever decisions you think are in that person's best interest, and to get all of those records and make those decisions for them, even when they don't want you to. So, as I said, you can file at age 17 and a half, that's 17 years and 6 months. And the hearing will happen before that 18th birthday. But it is effective on the 18th birthday because you have all of those rights as the parent right now when the kid is not 18 yet. So that's when it's going to go into effect. We do minor guardianships, but those are typically where we don't have a parent. Maybe the parents are deceased, maybe the parents are in prison, maybe there's some other reason. So those are done in juvenile court, but all the rest of the guardianships are all done in the probate division at the Superior Court. And the closest court to us here would be the one that's at Union Hills in the 51. There's a courthouse there, and if we file the action, that's where all of our cases go. It goes by the zip code of the filing party. So depending on what your zip code is when you file, is where you get assigned. And I will tell you that it is not as straightforward as you might think. So our office is in Scottsdale and McCormick Ranch, across from the post office. And that, where our office is, we would have to go downtown if we used that office address. Literally the post office, which is across the street from the office, is in the district to go to the Northeast Judicial Court at Union Hills in the 51. So don't just think because you live in, a certain zip code, you're gonna get assigned somewhere. Again, I only warn you because people are like, why do I have to go all the way downtown? So it goes on the zip code of the filing party. So there's a lot of paperwork that goes along with filing a guardianship. And you have to, if you're gonna do it on your own, which is totally fine, you go on the court's website, there's a self-service center that has all the forms and the instructions, and it's very well laid out as to what you need to do and how many copies to bring and what you need to do. You can't skip a step. If you skip a step, it doesn't work. So, for example, you have to call to get what's called court-appointed counsel. If you don't have court-appointed counsel at the time of your hearing, and I'll talk more about that in a minute, your hearing will not go forward, and then you'll have to get it reset again. So, if you're gonna do it on your own, just make sure you follow every single step that's set forth in what you need to do, and make sure you bring as many copies of each document as the instructions tell you to bring. Because if you don't have enough copies, you can't get it to all the people who have a right to see the information. A lot of times people are concerned about doing a guardianship because they want their kids to continue to be able to drive or to be able to vote. And you can still do that in a guardianship. So we can carve out the things that your kid is still going to be able to do. Those are the two biggest that we usually are looking at, is voting and driving. And a lot of times the kids think that they're going to go to court and get a driver's license because we've given them they retain their right to vote or to drive. The judge is not handing anybody a driver's license. They still have to go through the same process. It's just that if we say that their right to drive is suspended, that information is directly provided to the Department of Motor Vehicles, and they will not be able to get a driver's license. They can still get the state ID that doesn't expire, but they cannot get the driver's license. If you're not sure, or the doctor has said that your kid shouldn't be driving, you can still later go to one of the driving schools like Driving to Independence or whatnot, that will do simulations and see how they're doing, and we can always go back to court later and say they're doing really well and we now would like the ability for them to get a driver's license. We call them permanent guardianships, but there's nothing permanent in any of this. So you can go back and terminate a guardianship later because your kid has matured to the point where they don't need a guardian anymore. And as I said, you can get their driving privileges. You can get their voting privileges back. They can get suspended later because some other bad thing happens and they're now no longer able to do those things. So don't be afraid of doing a guardianship because you think they will lose all of their rights. We can carve out the things that might be important. I've kind of gone through on this slide what the big steps are in terms of the paperwork that needs to be completed, and again, make sure you do all of it, and make sure that you have them completed fully. The clerks are great at the court, but they can't give you legal advice. So they may say you missed a step, or you didn't fill this part of it out, and try and direct you in the right direction. But you need to make sure that all of the documents are prepared. So as to who can be appointed, pretty much the statute has a list of priorities, which is what you would expect the priority list to be. If you are divorced, then we have to look at the custody agreement that was in place when the child was, under 18 years old, and the court will give that some weight. You can have co-guardians, so you can have both parents be co-guardians together. You can be co-guardians with your other adult child over the person who is in need of the guardian now. As I was saying, if you're divorced, you might end up with a whole new fight. You can be co-guardians unless you don't get along at all and can't make good decisions for your kid. Then we might have some other litigation about that. But it can be who you want. And as you age, we tell parents, it might be time at some point in the future to add one of the other kids on as a co-guardian. So if something happens to you, they've already been appointed. They've already gone through the whole process, so you don't have to worry about any kind of lapse in time as to when somebody's going to have control. And if you could just write your question down, that would be fabulous. Only because we're Facebook Living, which I've never even been on Facebook on live, so
you're doing great for your first time.
Oh, and if you have a criminal history, it's going to be more difficult to become guardian. There's an affidavit you have to complete that says that you're not a felon and you're not on the elder abuse registry. So those are all kind of normal, typical things that might come up. So we talked about you can be co-guardians, so both parents can be on there together. So lots of people will come into your life if you're going to apply to be guardians. We have the court, of course. We also have court-appointed attorneys. So every case in the state, the person who's been, we're claiming is incapacitated, will get their own attorney that the court will assign for them. It's required by statute. We have parents all the time who say, well, can't you just represent my child as well? I can't represent you as the parent petitioning for guardianship and your kid. So the court-appointed attorney's job is to meet with your kid and find out what they want and whether they're okay with the process, and to the best of their ability explain what it means and what it's all about. Court-appointed counsel is not necessarily looking out for the best interest of your kid. So if you have a child who's very, I only use the word obstinate, I don't know a better word, who's going to be uncooperative, and they say, absolutely not, I don't want a guardian, I don't need any help, I'm completely fine on my own, and the minute I turn 18, I am not living here anymore. That attorney is going to go in and say, there's an objection to the guardianship, and the court's going to set it for another hearing where we can hear from the physician, and we can maybe hear from the school system or the caregivers or the case managers, maybe the doctor, and sort of get some more information. So if everything goes swimmingly well, you'll get appointed at that first hearing, but they are entitled to object. It's a big deal to be under guardianship. So just so you're prepared for that. We also have court investigators. Those are court staff, for the most part social workers. I think we have 4 for all of Maricopa County. I don't know how they keep up with the caseload, but they will have a conversation with you as the petitioner, the one who's filing your petition. They're going to have a conversation with any other family members who they think would provide information that might be useful. They're going to come and meet with your kid either at school or at home or at camp or wherever it is that they are when it's time for them to go out. Most of the time they're going to meet with you all about 2 weeks prior to the hearing, so don't freak out if you haven't heard from them for a little bit. And they're going to provide a written report to the court as to that they've been to your home, that it's clean and tidy, that the kid has a place to stay, it seems like a safe environment, you understand your responsibilities as guardian, it's in the best interest of this person given the medical report and other information. So they're going to provide a written report, and it would be very, very rare for the court investigator to actually show up at the hearing. I've only had it done once in the 20-something years I've been doing it, with a very, very nasty case between 2 sisters who hated each other over who was going to be guardian for mom. So it would be very rare for them to show up. They just provide a report. I will tell you that what you say to the court investigator will end up in the report. So if you say, my ex-husband's a jerk and he never has paid me child support and that's why he should not be co-guardian with me, that will be in the report that your ex-husband gets to see. So you should be honest and forthright, but you should have a filter when you talk to the court investigator to make sure the information is something you're going to be comfortable with later. We need a doctor's report. The court has a form for that, and so that's a kind of a check the box so that we can see what's the diagnosis, any medications, has the person been hospitalized, do they need a guardian, where should they live, all that kind of basic information. And it's required, and I call it a physician report, but it's really a health professional's report. So it can be completed by a registered nurse, a nurse practitioner, the physician assistant. I'm not sure any of us actually see doctors anymore. So all of those ancillary folks in the medical office, they can fill it out. And assuming the person does not need inpatient mental health treatment. So if you have a kid who has mental illness and they've been hospitalized before, or you believe that they may need to be hospitalized within the next 12 months for a mental health issue, then the report has to be completed by a psychiatrist or a psychologist. And then, of course, there's you, the overwhelmed proposed petitioner there. Everybody has to report, like I said at the beginning. The hearings are super straightforward. If nobody objects, they might take 5 or 10 minutes. Plan to be at the courthouse for about an hour. The court typically has 3 cases set at each time, so maybe your hearing's set for 9. There might be 3 cases all at 9, and 3 cases at 9:30, and 3 cases at 10, and 3 cases at 10:30. So you're gonna maybe sit there for a bit. The cases, for the most part, are public. If you are interested in seeing what does a guardianship hearing look like, you can call our office, and we're happy to check the docket for you to see when the next hearing is for anybody. Or you can go on the court's website and you can look up the commissioner and see Commissioner McLaughlin is the one who handles these matters at Northeast. You can look on her calendar and see when there's a guardianship hearing, and you can go and sit in the back. And you don't have to tell anybody why you're there or what you're doing there, and it's free and it's open, which also is free and open when it's you. So you have to know that the information that you're saying out loud, everybody else in the courtroom will hear, and anybody can get the transcript. What's not available is your personal information, dates of birth, addresses, phone numbers, things along those lines. Those are all confidential documents, and anything related to money. There is a mandatory training. I've put it on the slide for you. It's free. They're like slideshows. There's one for guardianship, one for unlicensed fiduciary training, and then there's also to be a PR and be a conservator and some other things. I strongly suggest that you go and you watch it. It's, like I said, it's free. You have to do it if you're going to be the guardian, but it goes through what to expect, what your responsibilities are. So it's kind of a really nice introduction to how guardianship works and what to expect. If the person you're filing for doesn't have any income or assets, or even if they're just receiving Social Security benefits, maybe they're on getting services through DDD, then you can ask at the time you file the petition to have all of the fees waived, which is a really big deal. The reason it's a big deal is court-appointed counsel, even though they're appointed by the court, they're not court staff. They're individual private lawyers who just happen to be on the list. If your kid has money, that person is going to get paid from your kid's money. And so that can save, I don't know, $2,000 or $3,000. Also, the court investigator fee and the filing fee together are $600 and something. So it saves that. Getting certified orders at the end of your hearing are $30 each. You'll get them for free. So at the time you file, you want to make sure you request the deferral so that you don't have to pay the funds, the fees. And then at the court hearing, the judge can actually sign off to waive all of those. Your kid, who we call the ward, which is kind of a terrible word, but that's the word we have in the statute, that person either has to be at the hearing or they have to be personally served by a process server. In our office, we process serve every single kid, whether they're going to show up or not, because I don't know when they're going to be sick. I don't know when they've decided school is better than going to the hearing. I don't know what's going to happen at the time we get the hearing, so we just make sure that they get served. But those are your options. If the child is not there and has not been personally served with an affidavit from a process server, your hearing will not go forward. As I said, guardians pretty much have all the power that you have as a parent to say yes, no, maybe, and to see all of the records. A guardian is not a conservator. They're not a trustee of a special needs trust. You might be in those roles also, but a guardian is the person who makes health and housing decisions. A conservator is the one who handles money, and a trustee is the one who manages a trust. Don't just file for conservatorship because, well, just in case I need it. Because if the child doesn't have any money other than Social Security, and you're probably the representative payee, which we'll talk about in a bit, there's just no reason to file for conservatorship, and the court will have to cross it all off and give you different orders, and there's different powers and different responsibilities. So just be cognizant of that. A guardian can also manage up to $10,000. So if you're the guardian and your kid gets a small inheritance of $10,000, you're still fine. But if they get $50,000 and they've already been deemed to be incapacitated and you're the guardian, then we might have to go back to court to do something else to manage those funds. So if you move out of state, the court you have to keep the court apprised of your address. You have 10 days to tell them if you move and 3 days to tell them if your kid moves. However, if your kid moves out of state, then you want to transfer the guardianship, then we have a process for that, and typically you don't need hearings for those, and almost all the states are part of our Uniform Guardianship Act, so you shouldn't have to have another hearing in the state that they're going to move to, although some states you still need to do that, like California, which doesn't do anything uniformly. So some states it's a problem, but most of the time we just have to let the court know we get an order to allow the transfer, and then you can go ahead and move. So I don't want you to feel like if I do the guardianship in Arizona and I get a job in a different place, I can't ever do anything, or you don't tell the court and you take your job in Connecticut and you've all moved and nobody knows about it. That's not a great plan either. There's an annual report of guardian that has to be filed each year along with a new physician report, and that's the way for the court to find out what all the things you didn't tell them about, like you don't live here anymore. So really important. You can terminate the guardianship if the incapacity goes away, and if you don't want to be the guardian anymore, you can withdraw to be the guardian and leave it up to the court. So once you're the guardian, you don't have to be the guardian forever. Once they're under guardianship, they don't have to stay under guardianship forever. That's what I mean about we call them a permanent guardian. It's not really permanent. It's only as permanent as we need for it to be. Sometimes people ask me, well, can my kid just sign a healthcare power of attorney and not do this whole guardianship pain in the neck court thing? And the answer is sure. If your kid's competent and they can understand what a healthcare power of attorney is, that's the least restrictive way to get powers. Remember, however, that while your kid's competent, if they don't want you in the room with the doctor, they don't want you talking to the doctor, they don't want you making decisions for where they're going to live, then the healthcare power of attorney isn't going to help you. Like, I have a healthcare power of attorney with my husband listed as my agent. If I said, I'm not going to tell you about my medical condition and you don't have a right to talk to my doctor, he doesn't. If I'm under guardianship, then it's another story. He still gets all the information no matter what. The other thing is that if your kid gets mad, they can throw away the healthcare power of attorney. They can give it to somebody else, right? They can cross you off, do a new one, and put somebody else in as the agent. So it just depends on how cooperative they are and what their capacity is. If they can understand doing estate planning is a great thing to do, including a healthcare power of attorney. If they cannot, and you need to continue to make decisions post age 18, the guardianship is really the way to go. So as I said, you can file for the deferral. That court investigator fee and filing fee is $679, court-appointed counsel, and if you hire an attorney, that's what all the costs are. You can totally do it on your own. As I said, the packets are available at the self-service center at the court's website. So that's guardianship in a nutshell. And I can't take questions, so don't ask any. So just write them down so you don't forget. And I have no idea if that's actually right. Okay, perfect. So we're going to talk about special needs trusts. I should have asked, has anybody been through the guardianship process? Oh, we have one. Fantastic.
With you.
I don't disclose anybody who's a client in the room. So we're going to talk about special needs trusts next. And the whole goal of a special needs trust is that assets are in a trust, but they don't count against the person who's receiving DDD all-tax benefits or SSI. Those are the two programs, for the most part, that we're concerned about. If a person has assets over the $2,000 limit, that they're no longer going to qualify for those benefits, and so they're going to lose the benefit. And the trust, the special needs trust, is the way to allow them to have money in a trust, not that they have direct access to, and still qualify. So that's the whole purpose. Sometimes people will ask me, if the person is on disability benefits, Social Security disability income, do we need a special needs trust? And the answer is no. But for most of you, since we're in a school system, I presume you have kids who don't have a work history who would qualify for disability benefits, because to get Social Security disability income, you have to have worked a number of quarters and actually paid into Social Security in order to get the benefits. SSI, which we're going to talk about in a minute, is for somebody who's disabled, has income that's low, and it has assets of no more than $2,000, but has not paid into the system, which is pretty much all of the kids who have a developmental disability. For the kids who have a traumatic brain injury or something else happened later in life, they may have paid in and be eligible for some disability benefits. One of the hallmarks of a special needs trust is that the beneficiary does not have a debit card. They don't just get money whenever they want it. They can't just use their card and take cash out whenever they feel like it. The trustee is completely in control of making the distributions. And for the most part, the trustee is going to pay the vendor directly. So if the kid needs a car, then the special needs trust is going to buy the vehicle, take a lien against the car. So if the car is in an accident or when it gets sold, the money's going to end up back in the trust again. If the kid wants to go to camp, the trustee is going to pay the bill directly to wherever the kid is going to camp, so that the money doesn't pass through your child. If the money passes through your child, for that moment in time, they're probably ineligible for benefits, and it would need to be reported. So that's the hallmark of a special needs trust. The other part of it is that it's not like the kind of trust that says at this age the kid's going to get this much money, and at this age they're going to get this much money, or they get $1,000 a month. It's 100% discretionary on the trustee to be making those distributions. And the trust says that its purpose is to supplement the other benefits that the person has. So for example, if the kid is in a DDD group home and DDD is paying for that group home, the trust maybe is going to pay for a private room there instead of a shared room. Or the trust is going to pay for them to go on an outing that maybe DDD is not going to cover the cost for. So it's going to cover those extra things that aren't covered by the government programs. When you have a special needs trust, just because I think I have drafted the most perfect trust under the sun, it has to be reported to the agencies that are providing benefits to the kid once there is 1 penny of money titled to the trust. So you can't just do it and then hide it and then not tell anybody about it. You have to disclose it to the agencies. So we have basically 2 different categories of special needs trusts. We have first-party special needs trusts, and then we have third-party trusts, which I'll talk about them separately. So these first-party special needs trusts are the trusts that make people anxious, because this is the trust that says if the kid dies, anything left in that trust account first goes back to Altex to pay it back for the services that were rendered to the kid. These kinds of trusts are created when the kid gets their own money. So my niece Marissa has Down syndrome. If I were to die and have a life insurance policy and it just said to Marissa, she gets the life insurance policy, the money, and then of course her mom would say, well, that's not going to work because she's just lost her DDD benefits and her SSI, then this first party trust would have to be created because I left money directly to a person who's on government assistance. And so it's nice, the government says you can have $3 billion in your special needs trust, which is really nice of them to say, and we'll continue to help pay for services. However, when the kid dies, then we're gonna get paid back for the services we provided. And so it's kind of like a loan, but if there's no money left in the trust, or the trust doesn't have enough money to pay the state back, they don't go after other assets, they only get what's left in the trust. And there are essentially two different kinds of these trusts. These D4A, D4C, that's just from the statute so that lawyers can keep straight which we're talking about. So D4A trusts, of course, have that payback language that I talked about, but that's a trust that your lawyer would draft. And so it could be, you know, maybe it's more personalized to your kid, although we have to follow the statute. So we have very clear statutory guidelines on what it can say and what it can't say. These D4C trusts, those are pooled trusts, pooled special needs trusts. So that's where we have a professional trustee, they're all nonprofits, and what they say is you're join the pool, like jumping in the swimming pool. We're gonna keep your kids' money segregated in terms of for accounting purposes, but for making investments, it's all pooled together and then we separately account. These work really well for maybe smaller sums of money, or when we don't have a family member to act as trustee and it's not enough money to put at a bank to act as trustee. And they're great, and it takes all the responsibility off of you as a parent, because that trustee is gonna do all the reporting that needs to happen. They know what the money can and can't be spent on, how to manage it, how to make sure the money gets to where it's gonna go. So really helpful as a kind of a substitute for having to pay a bank or a licensed fiduciary or somebody else to act as trustee. These are specific by the statute, can't create them for people over 65, and then they have all kinds of bells and whistles to them as to what you can and can't do with the money by statute. Then we have third-party special needs trusts. We think of these as estate planning trusts. So if I were smarter, instead of leaving the money to Marissa in my life insurance policy, I would have left it to the trustee of the Marissa Trust. And so these kinds of trusts don't have any payback to the state. So I could say when Marissa passes away, if there's any money left in it, it then goes equally to the other nieces and nephews that I have, and that's totally fine. And there's more flexibility because I don't have a list from the statute as to what the money can and can't be spent on. So these are the kind of trusts you want to make sure that you have as part of your estate plan to make sure if you're going to leave money to your kid who's receiving DDD services or SSI, they won't lose them. We don't have to go back and create this first party special needs trust, and we won't have any payback problems. Does that kind of make sense, hopefully, to people? Sometimes people come to my office and they say, I just want a third party special needs trust. Well, you have to think in your head, you probably need at least a will, if not your own trust. I need somewhere to direct it into, right? So if I have an account in my name and I die, I need to get it there. I could also set my accounts up to be payable on death to the Marissa Special Needs Trust. Free, you do it at the bank. You can do that with IRAs on your beneficiary forms. So there are plenty of options to have a fairly simple estate plan and still make sure we're protecting your kid's money. But it has to go into that trust in order for the kid not to lose benefits if they inherit money or money is given to them and it's more than $2,000. First party special needs trust, we have a list in the statute of what we can spend the money on, and third party trusts, we have more flexibility, although it's still for the sole benefit of that disabled kid. Both have to be reported to Social Security and Alltex when we have 1 penny in them. You open a bank account in the name of the trust, you must report the trust and all of the funding sources to the agencies that are providing services. And I tell you this because if you don't do it and your kid's on SSI and Social Security finds out about it later and it needed some minor tweak to it that you haven't done for the last 10 years, Social Security will ask for all of the money that they paid to the kid back. That's an overpayment and it's a problem. So we want to solve the problem before it becomes a problem, or while it's only a little bitty problem. You want to make sure you have a trustee who's going to outlive your kid, because otherwise it's not very useful. There won't be anybody to manage the trust. So if you do estate planning, you want to review it every year, every 2 years, make sure it still works, make sure everything's going okay, so that you always have somebody who's in the right position to act as the trustee. You can also, you can, if you really, really, really like your other kid, but you feel like I don't want to burden them with being the trustee and they're too close in age and I don't want to put the two of them at odds about money, you can name your other kid to be the one who picks the trustee, but not be the trustee. So you can have language in the trust that says, you know, my daughter Sarah shall be the person who can pick a trustee and remove a trustee and can look at accountings and do other things like that. Typically in a trust document we call those trust advisors or trust protectors, but you don't need a fancy name. So there's lots of choices to get to where you need to be. So first party trusts come up all the time when we have probates and money's going to go directly to that incapacitated person. And also personal injury awards. So sadly I've had a couple of kids where we've done a guardianship, they have autism and they're out on their bike and they got hit by a car. So now we have personal injury money that we need to fund into first party special needs for the benefit of that beneficiary as well. And third party trusts, so I drafted a third party trust for my family for Marissa. My husband and I have no kids, my brother's got 5 of them, my sister doesn't have any kids. And so I drafted it, my mom signed it as the grantor, the creator, and then each of the rest of our estate plans say the share for Marissa goes to that trust. So the money can come from a whole bunch of different sources. So I did an estate plan for a couple about 2 months ago. We created a special needs trust for one of their kids, and then the dad came in to see me, and we just have his trust also say, hey, the share for this kid is going to go over here to that trust that the parents had created. So it can get money from a whole bunch of different places. We talked about the reporting requirement. I don't mean to hammer on it, but it's just important because it can create problems later, that's all. So that's special needs trust in a nutshell. Super complicated in 20 minutes. We're going to talk about ABLE accounts. Anybody open an ABLE account? Oh, we got one. We got one on each topic. Okay, so ABLE accounts, Achieving a Better Life Experience is what ABLE stands for, if you care. In the packets or the extra copy, I gave you a handout on Arizona's ABLE program. So this nice gentleman had been fighting for years to figure out a way to allow his son with Down syndrome to be able to save money, right? Isn't it awful? You teach, all of us learn to be fiscally responsible and not spend all our money, unless you're on SSI or Altex, in which case you need to spend all your money because you can't have more than $2,000 in the bank at the end of the month. So ABLE accounts are a way for somebody who's receiving those kinds of benefits to still be able to save money. So, so that's their whole purpose. And every state has, most states anyway, have an ABLE program. We have one in Arizona. And the information is on your handout at az-able.com. And you have to be disabled prior to age 26. I don't know how the government picks these things, but that's what the statute says. If you're disabled at 27, you can't get an ABLE account. You get hit by a car and you have a traumatic brain injury when you're 27, no ABLE account for you. But if you were disabled prior to age 26, then those accounts can be set up. You can only contribute per year to an ABLE account no more than the gift tax exclusion amount, which this year is $15,000. Used to be 10, so that's a number people recognize as 10,000 as gifting, but it's 15,000 now. That doesn't mean that mom and dad can each contribute 15,000 to the account. 15,000 total in a calendar year, and there's no catch up. So you can't say, well, I didn't create it, so now I have these 5 years in which my kid is now 5, I want to put 5 years in. There's no catch-up provision. So you can contribute up to $15,000 a year into the account. As long as the account remains at no more than $100,000, then they will not lose their SSI, it will not be suspended, and they will not lose their Altex DDD benefits. It's a really useful program, and the program in Arizona has a debit card, basically a prepaid debit card. So you can order that. It looks just like a credit card. It is not embarrassing to have. And then you can use it when you're out and about and the kid needs a haircut, or they're going to the movies, or you're picking up stuff at CVS for the kid. Whatever it might be, you can use the card and then the money will come out. The money that comes out of the ABLE account is not counted as income to the kid, so it doesn't impact their SSI or their Altex DDD benefits. And you should keep receipts or an accounting of how the funds are spent, but I've not had Altex ask for an accounting of the use of the funds. I have not had Social Security asks for information about the use of the funds. And the only rule for how you use the money is what they call qualified disability expenses, which means pretty much anything that's helpful to the kid. So that can be clothes, that can be a new computer, that can be a phone, that can be going to a museum, that can be going to the movies, that can be going on vacation. Pretty much anything that benefits the kid. The ABLE accounts also grow on a tax-free basis. They're in the tax code, the same place 529 plans are for education expenses. So the money that's invested in the ABLE account will grow tax-free and it comes out tax-free. If you use it wrongly, which I literally don't know how you could do that unless you give the money away to somebody else, the only penalty is to pay the tax on the amount of the growth related to the distribution you got. Okay, that's a really, really tiny number. So the likelihood of any penalty is not only small, but the amount of the penalty would be tiny, minuscule. So it doesn't concern me as a problem. So they're useful for lots of different ways. You don't go to the bank and set them up. I get calls, I'm at Chase Bank and they don't know anything about these ABLE accounts. They're all done online. So you go to the az-able.com website. It has a great frequently asked questions section. Totally free to look at, totally free to set the account up. Have to open it with a minimum balance of a whopping $50. That's it. One of the downsides of the ABLE account is it does have that same payback that I talked about on the first party special needs trusts. So when the child dies, if there is money left in it, you can use it for funeral expenses, which you cannot for a first party special needs trust without absolute permission from Alltex. And you can use it for some other small administrative expenses, but other than that, the money would go back to the state. It's also really nice because you can give your kid the debit card. You don't have to be with them. So they're going to the movies with their friends. They can have their debit card, they can buy their popcorn, they can do what they want with the amount of money that's on it, but they can't get cash from the card. It's only to be used like a credit card to spend on things. Really good for small inheritances. You know, we haven't funded it and now the kid gets $15,000. You can put it in an ABLE account and not have to worry about the special needs trust. Great way for kids to try to learn how to use money. You put some money on it and they understand that it runs out. It doesn't fall from the heavens above and replenish itself. So it's kind of a nice way to give them some sense of independence. So that's how the ABLE accounts work. Okay, zooming right along. We're gonna go to SSI. Anybody's kid on SSI? There's gotta be one. Come on, we've had one for, yes! There's a winner, all right. So, Social Security, this is my favorite graphic because this is exactly how I feel when I talk about Social Security or when I have to deal with the Social Security Administration. If you are enjoying your communication with DDD, it is a walk in the park compared to dealing with Social Security. So we have needs-based benefits and we have entitlement programs. So when you reach a certain age or you are on Social Security disability benefits for 25 months, you'll get your Medicare benefits. I told you Social Security disability is based on the fact that you worked enough, you paid enough into the system, basically getting early Social Security retirement. But on this side, we have Alltex DDD under the Medicaid programs and SSI, Supplemental Security Income. I urge you with all of my urgeability that if your kid is approved, that you make sure not to lose your eligibility letter. Not because Social Security will ever ask you to see it again, but it is your proof that your kid is deemed disabled for getting SSI, if anybody ever asked why you set up your ABLE account when you did. But more importantly, if you talk to any lawyer to help you figure out what planning to do, they will want to see the eligibility letter, because clients come to see me all the time and say that the kid is on Social Security. Okay, there's lots of different kinds of Social Security, and the planning all depends on which branch of Social Security they're getting. So scan it in, keep it, know where it is, because it will come in use in handy later. So SSI has all kinds of requirements in terms of you can't have more than $2,000 of total resources other than a house and a car. Very similar to the Alltex rules. Any earned income has a calculation to decrease how much they get for SSI. Any money you give a person in cash is unearned income, and that is a dollar for dollar offset after the first $20. So if you hand your kid $100 every month and they're on SSI, you are supposed to report that, and instead of them getting the maximum SSI, it's going to get reduced by $80 because the first $20 is a freebie. So it's important to understand how it works. The maximum SSI payment is $785, I think, this year in 2020. But if you provide all the food and housing for your kid, they're going to get a reduction of their SSI, so they're probably going to get $500 and change for benefits. If they're living independently, which would be, I suppose, if they were in a DDD kind of a group home, and so their Social Security is now going as their share of cost, they should get the full Social Security, that full $785 a month. The Social Security is a national program, right? So everybody across the country gets the same benefits and the same amounts that they can receive. We like to use Social Security for the purpose of food and shelter expenses when we can, or just discretionary stuff for the kid to go and have fun and figure they're going to get a reduction on that SSI payment anyway. Don't apply for SSI before the kid turns 18 unless you yourself literally have no income and no assets. Because while the kid is under the age of 18, your income and assets are deemed available to your kid, and if you have more than $2,000, your child will not get SSI until they've turned 18. You will do your whole application, and then you will get a denial, and then you will reapply after they're 18. In some states, apparently they'll do the medical assessment first, and they'll wait to do the financial. So when I go to national conferences, they always say, you know, you should start early, and I know we all want to start early, right? We want to get it over with and know that it's going to be in place. In Arizona, my experience has been if you apply one day prior to 18 and you have any money, you have to disclose all of your money, all of your income, and the kid will be denied. You can call on their 18th birthday to make your appointment, and the application should be retroactive to the date that you called to make the appointment. That's the best you can do to get ahead of the curve. In the packet, I have information about SSI and all the documents you should bring with you. You should absolutely make an appointment so you do not spend your entire day at the Social Security office. They usually call your appointment pretty close to the appointment time, and if you brought all of your documents with you, they get it all in the system. The person you meet with does not make the decision, so don't say, is my kid going to be eligible? They won't have any idea. They just are inputting the information, and then it goes off to some person somewhere else, and they're going to review it all. Now, the likely outcomes for SSI are, like Marissa has Down syndrome, that's categorically eligible for SSI. So she's got a genetic issue, she has Down syndrome, so they applied and they got SSI right away. For kids with other kinds of developmental disabilities, like autism, we know autism is this, right? That's why it's called a spectrum. So you might have a kid who's kind of high functioning but not able to be able to work, because the standard is not to be gainfully employed, meaning that you basically can't work at a full-time job or earning minimum wage. They might send the kid to their vocational rehab specialist to do some testing and see whether they think that your kid might be able to work. You want to make sure you bring all your medical evidence, the doctors that your kid has seen, because they can get all the medical records to see what's going on. So you might go to they might go to a vocational rehab specialist and get some testing, and then they might either be denied or approved. You might get denied, and you might have to go back and do an appeal and provide more information to determine that they're not able to work. And when I say not gainfully employed, and it's basically full-time at a minimum wage job, there are credits though. So if your kid needs an accommodation, we had a kid who worked at the library, a client of ours, their child worked at the library, worked a lot of hours, made some decent money, but he literally had an aide with him the entire time. And he had to take lots of breaks throughout the day because he couldn't stand for that long. All of that goes in the record, and he still was receiving SSI benefits because they said those are accommodations. He's still disabled. He still will qualify for SSI even though he's earning money. There's also a kind of a work trial period that the kids can also try. So if they're on SSI and then they get a job, they just have to report, you have to report your wages every month, And then if the job doesn't work out, then they're gonna continue on the SSI, because the government actually understands that they might cycle through jobs and not actually be able to hold on to it long term. My niece Marissa works at a grocery store in the area where they serve food, and so she does the cleaning up of the people afterwards, and her wages are reported every month. She does not work full-time, and she needs a lot of accommodation, but she's out there doing her thing, so it just gets reported so she can maintain those benefits. It's a really great benefit. One of the things that's really good about SSI, which I don't know if I have a slide, oh, there we go. So if your kid is deemed to be disabled prior to age 22 and they stay on the SSI benefit and you or your spouse retires, they will get what's called a DAC benefit, a disabled adult child benefit, or it's called CDB sometimes, child disability benefits. Why is that really important? Because when you retire, they're gonna flip to that benefit and get 50% of the parent's Social Security when the parent retires. And they're gonna keep that forever, except when the next parent retires, maybe that was a higher wage earner. They can now get 50% of the higher wage earner's Social Security without decreasing your own Social Security retirement. And when a parent dies, the kid bumps up to 75% of that Social Security limit, and it doesn't have a $2,000 limit like SSI does. And on the 25th month after they started that benefit, they will get Medicare forever. And so I think the goal is to get Medicare, which is better than access benefits. So it's a really, really important benefit. I have some affluent families and they say, I don't want to take anything from the government, I don't need this. Well, it's the way to make sure your kid will always have health insurance. Health insurance is the scariest proposition for, I think, well, it's for me and certainly for folks who have disabilities, because at any time the government can just change the rules on you. And if you have private insurance, maybe you're not going to be covered. Maybe your premiums are going to go up. Maybe the access program is going to change and the eligibility criteria will be different. It seems hard for me to imagine that the government would ever pull Medicare away from people. So to get your kid on Medicare benefits because they were on SSI and then they can roll over and get that higher benefit, I think is really, really wonderful and important. The other use of your ABLE account is if the Social Security starts to build up in the account, you can move the money over to the ABLE account, again, as long as you're not adding more than $15,000 in a calendar year. You do the same thing with wages in the ABLE account. If the kid's working and the account starts to grow, you can move the money over to the ABLE account. So it's a nice kind of release valve as to where we can put the money and keep the person qualified for benefits. Great on my slides. So I left plenty of time for questions. I know it's a lot of information. I don't know how else to tell you the information other than to tell it to you. So is it okay if we open it to questions?